Welcome to Season 2 of B'Madzijig Ganonindwa. This podcast is produced by the Communications Department at the Anishinaabeg Nation. We will be focusing on the issues and initiatives in Anishinaabeg Nation territory. I'm your host, Lisa Abel. Since 1876, the Indian Act has been the primary federal law designed to exert power and control over First Nations identity, political structures, governance, cultural and spiritual practices, education, and lands. This law was imposed upon us despite our inherent rights and nation-to-nation treaty relationships with Canada. It ruled every aspect of Anishinaabeg lives, from cradle to grave. Within the Indian Act, the federal government defines who they consider an Indian. Their definition was not based on our own understandings of kinship and community ties, but instead privileged the right of First Nation men over women to pass on their Indian status to their children. By design, thousands of First Nations women and their descendants lost their Indian status, rights, and legal connections to their communities. Another way the Indian Act sought to assimilate First Nations people was through enfranchisement, where a person would voluntarily or involuntarily give up their rights as a status Indian in exchange for the rights of Canadian citizenship, which were denied to them. Many First Nations women have challenged the discrimination of the Indian Act in the courts. Our Anishinaabeg Nation Citizenship Commissioner, Dr. Jeanette Corbière-Laval, led the way in 1970. Eventually, these challenges in Canadian courts and international forums, as well as the adoption of the Canadian Charter of Rights and Freedoms, brought about incremental changes to the Indian Act. For example, Bill C-31 in 1985, Bill C-3 in 2011, and Bill S-3 in 2017. As a result, many First Nations people have been able to register or regain their Indian status, and First Nations now have an option of taking control of their band membership lists. However, the federal government still retains the power to determine who is a status Indian and how this status is passed down to future generations. In 2016, Canada officially signed on to the United Nations Declaration on the Rights of Indigenous Peoples, also known as UNDRIP. 5 years later, Bill C-15, an act respecting the United Nations Declaration on the Rights of Indigenous Peoples, came into effect. This law is meant to align Canadian laws affecting First Nations with UNDRIP. To implement the law, Canada created an UNDRIP action plan, which includes ongoing consultation and cooperation with Indigenous peoples. As they review the Indian Act, the government intends to collaborate with First Nations to seek solutions to make the Indian Act registration and band membership provisions more consistent with the UNDRIP. The Anishinaabe are determined that our First Nations have full control of our citizenship and band membership. Most importantly, we decide who belongs to our nations, who is recognized, and who has rights. We need to be able to pass on our status rights via one Anishinaabe parent, not the two-parent rule that is currently in the Indian Act. In 2009, the Anishinaabeg Nation Chiefs in Assembly adopted our own citizenship law, the Endbendogsijig Naknagewin. In 2025, a draft Anishinaabeg Nation Declaration on Endbendogsijig was created, which is an assertion of the inherent right to decide who our people are, not Canada. The Anishinaabeg Nation Declaration on Endbendogsijig, those who belong, or citizenship, focuses on Anishinaabeg Nation sovereignty, history, traditional governance, inherent rights, and Anishinaabe law, as related to our Endbendogsijig laws and cultural identity. I spoke with Anishinaabeg Nation Southeast Regional Chief, Marcia Smoke, about how the Indian Act has perpetuated inequities between First Nations men and women, and how they can pass on their Indian status, how the Indian Act limits how our communities manage and control our own membership, and how our Anishinaabeg Nation Declaration on Endbendogsijig and the Endbendogsijig Naknagewin our laws are the basis for our First Nations to assert inherent rights. Bonjour, I'm here with Marcia Smoke, the Southeast Regional Chief for the Anishinaabeg Nation and a citizen of Alderville. And as Southeast Regional Chief, one of your responsibilities is for the citizenship portfolio. So welcome to the podcast, Regional Chief Smoke.
Thank you. It's very nice to join you.
Before we start, would you like to tell us a bit about yourself and your role?
Well, Ani Bojo, Nigani Makwakwe Indigenous, Makwandotum, Kamadashkodeyang, and Dunjaba. My name is Marcia Smoke. I am a citizen of Alderville First Nation, and I took on the role of Southeast Regional Chief in June of 2024. And I've spent my lifetime working with First Nations, and whether it's in remote communities or in more settled areas. It's been wonderful. I've had different roles throughout my lifetime, whether as a band manager, whether the head of a band development corporation. I've held positions with the people in the Cree territory and in Quebec and EOSG, and I had an opportunity to work with a lot of leadership over the years and had very good mentors and being able to accept their teachings at a very young age. So I really appreciate that, that opportunity. And throughout the years, I was involved in businesses, from owning a travel agency with my husband to getting into the construction business and working in that field. But the passion that I hold most has been to work with my consulting firm, which brings me to many different areas to share our history, to share our knowledge, and dispel the myths that are out there about First Nations. So it's that research and historical record that I like to work on and basically set the record straight when anyone, wants to engage in conversation about who we are as people. So it's been a really rewarding life history for me, and being with the Anishinaabeg Nation now and being able to share all this knowledge and work with the people to work on issues like this citizenship is very good because it's something I've been involved in my entire lifetime. So a lot of the work that I've done in terms of the citizenship has been mainly advocating for individuals who know that they're entitled to be registered and helping them facilitate their registration. And I learned from a very young age from my mother and my father, we were always taught to never leave anyone behind. And when you look at the policies of government and all of the people who have been excluded from being recognized within their communities, a lot of our people have been left behind. And now I have been following even back when Jeanette Corbier-Lavelle did her work on the national and international level to be able to have our rights recognized, and followed through when, after her court cases to see the government move towards Bill C-31. So from that perspective, I've been able to keep up to date all these years on what was transpiring and how our rights were gradually being recognized. So that's where my background is on citizenship.
Miigwech. So that's a lot of interesting experience. This issue of citizenship has certainly been evolving over the decades. But if we want to start to kind of understand how this works, you mentioned the idea of being registered, right? So that's the idea of someone who would be a member of a First Nation, but being registered at Indigenous Services Canada as a status Indian. Can you kind of explain that process, what that is?
Okay, we've got a long history of our people being excluded from being able to be recognized as our citizens. And the Indian Act has gone through many changes over the years, but initially, the reason why this all became about was because the Indian Act was not being treated equally between the men and women who were registered on our registry lists on the First Nations. So it goes back to the old explanation where if one of our women married someone who was not on the banned list, then they were automatically removed by the registrar. And that was one way of removing their status as we call it status Indian. That was one way. The other way that people were removed from the registry was through enfranchisement. And enfranchisement was where one or both parents, usually just one, made the decision to give up their status for various reasons. It could have been for education. It could have been to join the army back in the many years ago. And it could be the fact that you've got people that were moved to small pockets of land in those reserve boundaries where there was no ability to go beyond the reserve borders, because back in the early 1900s, people needed to have permission to leave the reserve and didn't have the ability to support their families because the hunting, fishing, trapping, gathering was outside those reserve boundaries. And we have to remember that in the 1920s and 30s, 40s, we had a lot of poverty. So we have a lot of people that were willingly enfranchising from their communities so that they could take their families beyond the reserve boundaries and practice those traditional ways of life so they could put food on the table, essentially. So some of it was for survival, some of it was because of education, some of it had to do with joining the armed forces. So once they did that, they were removed, the individual was removed, the spouse was removed, and then all of the children were removed as well. So that meant that at that point, no one from the generations on were going to be recognized as the rights they had. So both of those parents essentially could be status Indians originally, but once the enfranchisement took place, then they were both considered citizens of Canada and not First Nations. So the enfranchisement was so much different than the women losing their status because of marrying someone that was not a member. So that basically took everybody off the registration list.
Throughout the 1970s and 80s, First Nation women such as Mary Tuax Early, Yvonne Bedard, Jeanette Corbière-Lavelle, and Sandra Lovelace Nicholas challenged the Indian Act in the Canadian and international courts. Once the Canadian Charter of Rights and Freedoms came into effect in 1982, Parliament was forced to change the Indian Act. In 1985, Bill C-31 amended the Indian Act to conform with the equality rights guaranteed by the Charter. Bill C-31 brought about several changes. An Indian woman who married a non-Indian man no longer lost her Indian status, and those who had lost their Indian status for this reason were allowed to apply to have their Indian status returned to them and their children. The process of enfranchisement was removed, and people who had been voluntarily or involuntarily enfranchised under the Indian Act could apply for the return of their Indian status. However, the federal government did not give up control over Indian registration, and new categories of registered Indians were created in the Indian Act through Sections 6.1 and 6.2. After the break, we'll hear how changes to the Indian Act continued to limit our ability to pass on our Aboriginal rights to the next generation. Ani lifelong learners, are you looking for Indigenous-led post-secondary education? The Anishinaabeg Educational Institute, AEI, is now accepting applications for fall 2025. Choose from programs like practical nursing, Binojinyak Kinomaduin, early childhood education, Native community worker, and more, all rooted in cultural knowledge and centered on community care. Visit aeipostSecondary.ca to apply today. Mamwi Gikandasaman, we learn together.
When the government created their legislation, which was Bill C-31, what they did was they said that those women could be registered and their children up until the second generation. So we now have the second generation cutoff. So we're still dealing with different ways that the government has put in place to not recognize the children and future generations.
We understand that Bill C-31 really didn't go far enough and made things more complicated now that there were categories 6-1 and 6-2. How is that impacting people having these different categories of status?
Okay, basically 6-1, this is how I explain it to people. 6-1 is there to recognize that you are registered in the government records with both of your parents being a status Indian. So that's 6-1. And then 6-2 was created to register the children if one of the parents was not a status Indian. So it's so complicated on how people are registered. So if you have two 6-1 parents, then your child is 6-1. If you have a 6-2, that basically means that one parent is 6-1, the other parent is not an Indian. So the child of that couple becomes a 6-2. Okay. So where this starts to affect families is, so you have, as I mentioned, a 6-1 parent and another 6-1 parent, the child becomes registered as a 6-1. And then if a 6-1 parent has a child with a 6-2 parent, okay, that child still is born as a 6-1. And the next step is, even if you have two parents, that one is a 6-2 and the other is a 6-2, the child is still considered a 6-1. So you're basically replenishing that membership. Okay, I don't know how else to say that. Okay, but then we start to get into the second generation cutoff, because once you have a 6-1 who parents a child with someone who has no status, then that child becomes 6-2. And this is where the second generation, and of course, this is all those who were born after 1985. So then once you have a 6-2 member that parents with someone that has no status, then that child has no status. So you're only safe for one generation if you're a 6-2. So then, it's just really ridiculous, because the government is deciding who our families are. And that's not right, because I know who my family is. And we all know who our families are and our children. But in reality, that second generation cutoff just means that that's the end. And the difficulty with that is that it's basically terminating our citizens, so that our communities they're going to have less and less First Nations in there, to the point of extinction. And for some of those smaller communities, it's a real tragedy, because, we've got some communities where their whole next generation, no one has status already. And it's going to be really, unless they find, a partner that has status, then, they can start to bring that status back. But it's not the ideal way to try to build a relationship with someone, just, to protect your nationhood. So the government has made a real mess of it, but we know we can get out of it. That's the thing. That's one thing about that I learned over the years, is that the government can put all these challenges in our way, and they can make all these rules. They can make all kinds of red tape and hoops to jump through, but we're still here, and we're resilient. We find our way. We'll be able to, work through this. So, and there is a way forward. So,
What really were the impacts of this loss of status?
okay, so as soon as someone is removed from the Indian Act, okay, they are required to get off the reserve. They have to leave because this all comes back from the colonial Indian agent days and that practice. And this goes back to the 1800s too, because I've been monitoring a court case where enfranchisement was involved, and provisions in the back in 1896 required individuals, as soon as they gave up their status, they had to move off the reserve immediately. And that was no different when it came to women that lost their rights. So that was just the procedure that was in place. And that was the law of the Indian agent. And because that became the practice, once our First Nations came to a place where they were starting to kick out the Indian agents and starting to run their own operations, they still followed the same procedures. And so in modern day, when people lost their status up until 1985, they were still required to leave the reserve. So yeah, only in 1985 did it stop. So I can imagine what it would have been like for the women back that regained their status and had that opportunity to come home.
I guess this impacted many people who experienced then this loss of closer family connection or loss of language or not being able to be close to the land where your community is from. That must have some impacts.
There was a lot of impacts because yes, there was the loss of the rights, being able to exercise your rights, but the biggest impact I think would have been the emotional impact, being forced to leave your home, the trauma surrounding it. Yes, not being able to speak your language or not having anyone to speak your language to, when you're moved away from your community. And just being out there, not really fitting in society because you may be, and I'll use this word even though, it's not politically correct, but being the only Indian in an urban or a, rural setting, or the only Indian family there, and having to face the challenges that your children faced because racism was rampant. People didn't have their arms outstretched welcoming Indian people into their communities. So there was another whole sense of trying to learn how to fit in that and live in that world. So many different experiences that people went through. I wouldn't even be able to, say what some of the women would have experienced. So it's heartbreaking when you really put some time to think about it because people are being forced to leave the only place they ever knew as home. So just another piece of government legislation, or the same legislation that displaced our children through residential schools, the same legislation that displaced our women because of who they chose to partner with or those who chose a different way of living. It was all wrapped in the Indian Act.
The fight against gender discrimination in the Indian Act continued. In 2011, in response to the McIver case, Bill C-3's modifications to the Indian Act granted 6-2 status to grandchildren of women who regained status in 1985. However, the ability to pass on status was unequal, depending on whether a person was descended from a male or female Indian grandparent or parent. As a result of the 2015 Descheno case, Bill S-3, passed in December 2017, fixed additional residual inequities with the Indian Act. The Act also required that Canada consult broadly on issues around Indian registration, band membership, and First Nations citizenship. This work continues with a collaborative process on the second-generation cutoff and Section 10 voting thresholds.
So what happened in around 2018 is that the government decided that they would reach out to First Nations and find out jointly how we're going to do this. So they put Bill S-3, even though it's received royal assent in Parliament, it's the law, they put it on hold until the First Nations were consulted on any of the issues that were going to be dealt with to allow people to acquire their status under this bill. So at that time, the government appointed a special representative, it was First Nations woman, to go across the country and talk to First Nations about any of the issues that were related to reinstatement or to register individuals. And I know in the case of the Anishinaabe Nation, of the 39 First Nations, 37 of them attended those meetings. So everyone deemed them very important to be a part of. So all of those items were documented. The report was filed by the special representative. It was tabled in Parliament, and they decided that there had to be a collaborative process with First Nations and the government to move this forward so that people could join the registry and be a part of their communities. What happened after that was COVID, and so everything stopped. And in the meantime, the Liberal government decided to adopt the United Nations Declaration on the Rights of Indigenous Peoples and to recognize our rights there. And so in order for the government to be able to move forward, they created legislation called the United Nations Declaration on the Rights of Indigenous Peoples Act. And in there, they probably tried to capture what was under UNDRIP, but they were very selective what wasn't. And so that came into place, that came into law. And then from there, they decided to create an action plan because, okay, we've got UNDRIP, we've got the UNDRIP Act. Now, how are we going to implement UNDRIP Act? So now we need to have the UNDRIP action plan. And that kind of makes sense, you know, in terms of process. But what it did, each time they do something, it kind of just goes towards watering down your rights a little bit more, a little bit more, a little bit more. And so where we're at right now is we're in that collaborative process to determine how we are going to implement that Bill S3 that recognizes all of our citizens as having the right to be registered in our communities. And the government has set a deadline of the winter of 2027 to try to come up with a solution. Now, the danger in this is that once we come up with something that is acceptable as a way to determine who our members are, the government wants to eliminate those sections of the Indian Act. So there's no going back. We're only ever dealing with UNDRIP Act after that. So it's a new piece of legislation. And like right now, we have to make sure we get it right, because when the government sent out their information to propose an outline of what this could look like for implementation, they put in there the two-parent rule again. And what that two-parent rule does is it just delays removing people from the registry or not allowing them to be registered for 2 more generations down the line. So they still want to get rid of us. Whether we have a number or not, we're not going anywhere, but we need our inherent rights recognized. We are a nation. We need to be able to determine who our citizens are. We know who our families are. We have that history. We have the grandmothers. We have, you know, the aunties. You know, we have our elders, the men that can talk about, you know, stories on the land. We still have that historical record, you know, in the voices of our people. So we cannot leave anyone behind this time. And as long as we have a role to play in it, then we have to make absolutely certain that no one is going to be left behind. So the Anishinaabe Nation created a citizenship law that the First Nations adopted by consensus that would recognize our future generations, our citizens, based on a one-parent rule. And that will bring us certainty that we can pass our genes on forever. So, and that's where we're going with this from a First Nations perspective, from a nation perspective. The Anishinaabe Nation, it has been active over these years to provide the tools necessary, the framework that First Nations can use to determine their citizenship. We have a citizenship law, Edibindogzijig Nocnagawin, that will recognize the one parent rule. So First Nations can use that as a guideline to when it comes down to doing the work in the local communities, if they want to follow that. We also are in the process of creating right now a declaration on citizenship.
This is the draft Anishinaabeg Nation Declaration on Edibindogzijig. 1. Creator placed Anishinaabe on earth along with the gift of spirituality. 2. Creator gave us sovereignty to govern ourselves. 3. We belong to the land and follow our own laws. 4. We have the right to determine who our people are. 5. Through our own governance principles and structures, we decide who belongs. 6. Together, all of us, we take care of each other, earth, water, air, fire, and all our relations. 7. We assert and exercise our inherent right of self-determination for the protection of our lands and our Edibindogzijig, as affirmed by the Anishinaabeg Nation Edibindogzijig Nocnagawin, 2008. Regional Chief Marcia will explain how this declaration was developed. Once accepted by the chiefs in assembly, the Anishinaabeg Nation Declaration on Edibindogzijig will be a guiding document for Anishinaabe First Nations to assert our nationhood and implement our Anishinaabe citizenship laws.
That is something that we worked on with, we brought people together from communities and said, what are the principles to recognize who our people are? And our Commissioner Jeanette Corbière-Lavelle, she's taken the lead on working with the people that had provided all that input on what a declaration would look like, and has been carrying the torch on this to get that information out to our communities and to make sure it captures the essence of what the people in that room ask for, and to make sure that we've had virtual sessions in our 4 regions so that we could introduce that. And we hope to, we have a bit of a time left yet to finalize that, but we're looking at the first week in June of this year, 2025, to present that to the chiefs in assembly and have that declaration accepted. So we've got these tools that First Nations can use, and we've been very clear that when it comes time to develop your citizenship law in your communities, that's the work that the communities do. That's not the work the Anishinaabe Nation does, because they know their people better than anyone. But we're there to support them and provide some background information like this that I'm sharing with you, that if they need our assistance, then we're certainly there to help. And it's really important that people understand what's at stake. So yes, we do have that winter of 2027 deadline that the government has put out there. But once we have this declaration, then we give that to government and we say, this is who we are. This is how we're going to do our work. So if you've got your winter 2027 deadline, that's fine by us, but we're going to work on this until we get it done and until we get it right. And it's going to be based on what people want, not what government wants. And we'll work with our people based on how comfortable they are and what the time is needed for them to be able to work this through with their members, because it's a very sensitive topic. And the whole idea for me is inclusion rather than exclusion. So I don't want to have to look around one day and in a room and see someone over there that they, for whatever reason, they weren't able to come back into that family circle because of the laws that we're creating locally. So these documents that we're providing from the Anishinaabe Nation gives them that background, so that it's a reminder of the importance of getting the work done in the communities and including everyone. So long answers for.
But I'm trying to understand, though, the connection between Our First Nations having our own citizenship laws. How does that connect to the fact that there's an Indian Act and there's still a register? Are you envisioning a future then where there's no more Indian register at Indian Affairs and that we're completely taking over control of our members or citizenship?
Yeah, that brings us into the second portion of this collaborative process on second generation, because along with that, there's sections under the Indian Act. Right now, everyone that is registered with the government is registered under Section 11 of the Indian Act. So that's where the government maintains the registry, because even though people apply for their status, the application has to go to the government. They decide. They go through their records and decide who is going to be added to the list. We have currently under the Indian Act a Section 10 that provides for First Nations to determine their own citizenship. So we do have First Nations that have moved to that area. Okay. The only difference is that under Section 10, the First Nations have full authority to decide who their members are. And they create that, back then it was called the membership code on how they become members. So that's up to that community. One of the challenges that became a part of Section 10 is you may have 800 people on your membership list under Section 10, but maybe only 600 are registered under Section 11 under the Indian Act. So once that Section 10 kicked in, after that, unless they were falling under the old 6.1 or 6.2, they're not included in the Indian registry. So we could have a significant number of people that are band members, but they're not registered Indians, which means they don't have the rights that go along with it when it comes to the rights to education, the rights to health care. There's others. Those are the most significant ones that affect individuals. It's still an issue right now. So we've got to, in our next work, under that Section 10, we've got to be able to work with that part of the Indian Act to be able to ensure that new members coming in are going to be included, not necessarily on the Indian Register, but have the same rights as those who are under the Indian Registry. And I'm not sure what that will look like. And I don't know if anyone is sure of that yet, because even when you look at all of the land claims agreements out there, all of those agreements, all the ones that I can think of, have all had their band membership protected based on the Indian Act. They've not given up their rights to status on any modern land claims agreements. So everyone is challenged with this. So ideally, we would have Section 10 with every community, with everyone having full rights recognized. That's one way of getting through that. And to be honest with you, I know the Anishinaabe Nation is doing this work. We may be taking the lead on this by setting up this declaration and setting up these tools that First Nations can use to be able to build on their own membership provisions. So it's all a part of the work. That's why I'm saying we have to get it right. We can't leave it. We have to think of everything and not leave anything out. So it's not just a matter of not leaving people behind. We cannot leave any of the tools behind that we need to be able to have support our identity that mainstream may want to refer to. So
I like that vision, though, as Anishinaabe Nations, having this full control of our inherent rights over our citizenship. It still seems like there's a lot of possibility there.
Yeah, I think that I really appreciate working with the leadership that is in place with the Anishinaabe Nation right now. We've got our Grand Chief Debasigi, we have Deputy Grand Chief Chris Plain, and we have our regional chiefs. And we are all moving forward with the same motivation, sometimes aggressiveness, all with the same intent of protecting our rights, asserting our rights, and holding government to account. with anything that they choose to get involved in, or anything they choose to interfere in our lives, we're on it. So it's really good to be able to work with with people that we're all of the same mind, and none of us have any fear. We have no fear of being able to put any of our visions out there, any of our statements. We're not afraid to step outside the box to look for solutions. And it's a really good feeling knowing that you're working in tandem with so many people that are of similar mindset. That's one of the reasons why I think that we're going to be able to do this, because we have no fear when it comes to dealing with the government or industry or anybody. So
Do you feel like we covered everything we need to cover for now to understand where we're at with Edben Dagzajig, our citizenship?
I think the only other thing that I'd like to emphasize is that it's really important that our citizens who are registered now be involved in this process, because they are the ones who have family members who are left out of their family circle because of the registration process. And any of the people who know they're entitled to be registered, or know they have a relative that is First Nations, but they may not be living near their community. They may not have that connection to their community. And there are a lot of people who have been basically through the 60s scoop, through residential schools. A lot of people have been displaced over the years, and all of those people who have been excluded so far. I really encourage everyone to try to learn as much about this and to get involved and to reach out, call some of the organizations, call for local First Nation, but it's important that no one gets left behind.
Well, miigwech for chatting today. Marcia, miigwech.
This has been a great opportunity, and I hope people take the time. I know it's a long interview, but for anyone who wants to learn about our history, this is who we are. This is our people. These are our families. This is our family circle. And it's time to bring the rest of our members back into our family circle. And we are the ones who decide that. Government isn't going to decide, because we know who our family is. So miigwech for the opportunity. I appreciate it.
Miigwech, our Regional Chief, Marcia Smoke. Miigwech. Miigwech to Anishinaabeg Nation Southeast Regional Chief, Marcia Smoke, for taking part in the podcast, and to the Anishinaabeg Nation Governance Department for supporting this episode. It is hoped that the Anishinaabeg Nation Declaration on Edben Dagzajig will be ratified at the Anishinaabeg Nation Grand Council Assembly in June 2025. Our leadership are trying to build consensus and inspire communities to adopt the declaration as the preamble to their citizenship laws, and to engender discussion on citizenship from a cultural perspective and based on inherent rights. To learn more about Edben Dagzajig, find the links in the podcast description. This episode includes the track Brothers by Wolf Sega and Chippewa Travelers, provided by Nagamo Publishing. Miigwech for listening to Bamadzajig Ganonindwa. Until next time, Bama P.